All right, our final case for today, now joined by Justice Hodgens, is 23P216, TAVARES versus Trial Court of the Commonwealth. Mr. Wheatley.
That's right, John. Good morning to the court. May it please the court, my name is Stan Wheatley, and I represent the appellants Doriana Medeiros and Joanne DeLucre, and they are two of many defendants in the trial court case below. This case involves employment discrimination claims.
You may not have been here at the beginning. We know the facts, we know the procedural posture and what the issues are, so we suggest you get right to your argument.
Okay.
And I do actually have a question for you at the outset. We understand this is, the issue here is union agents' liability or their immunity. And the question is it liability, is it immunity from liability or is it immunity from suit? Because if it's immunity from liability, that would not be appealable under the doctrine of present execution. That would have to wait until the end of the case.
You're absolutely right about that, Your Honor. In this case, it is absolutely immunity from suit.
And what case actually considers the distinction and comes down on the side of this kind of immunity being immunity from suit rather than liability? I know in the Montplaisir case and perhaps in the U.S. District Court case, Best it might have been called, there's language referring to this as immunity from suit, there's language referring to it as immunity from liability, but the court never considers the difference between those two and comes down clearly on one side or the other.
I think it's true, Your Honor, that in the older cases, in particular the Root case, Atkinson, did not clearly draw that distinction. But I believe the more recent cases, including Montplaisir, including Best v. Rome, and in particular this court's case in O'Keefe, decision in O'Keefe, clearly say that it is immunity from suit.
Where does it say that in O'Keefe? Actually, you know, I don't think we want you to spend too much of your time looking through it, but we may be asking the parties to submit something supplemental on this, and you can address it at that point.
All right. Yeah, in the brief, I cite Lynch v. Crawford, but that is admittedly just for the general proposition that a claim for immunity from suit is immediately appealable if it's denied.
Yeah, and so the question would be, which category does this fall in? And Lynch v. Crawford spent a lot of time talking about the distinction.
Right. I'm happy to submit something further on that. I'm quite confident that the cases taken together do talk about this in terms of immunity from suit, not just immunity from liability.
Okay. While we're on the topic of immunity, slightly different than Justice Sachs' issue, let's talk about whether the issue's waived. It wasn't brought up before the lower court, the issue of immunity, and it wasn't. Well, let's start with that. Why aren't you precluded from raising it now?
Well, it wasn't brought up in the original answer that was filed. I think that's what you're referring to. But it certainly was brought up in the form of a motion to dismiss in response to the amended complaint. And for the reasons that are cited in the brief, I think that that's permissible on a number of levels. Actually, that's dealt with mostly in the reply brief. And the biggest problem with that waiver claim is that it wasn't raised in the court below. If the plaintiffs wanted to argue waiver, they had their chance to do that when the motion to dismiss was first filed, and they failed to do so. There's also a question about whether or not a claim from immunity from suit is an affirmative defense at all. That wasn't, they didn't address it, so they never cited any authority to support that. In their appellate brief, the case they cited does not apply to this situation. And the other thing that's critical, I think, is that they did file an amended complaint. And it was a big amended complaint. It was not just a subtle little change. It was a huge change. And I think the case law cited in the reply brief supports the proposition that when you file an amended complaint of that magnitude, you open the door to new affirmative defenses, and that's the position that we take here.
So even though you're taking the position it's not necessarily an affirmative defense, it was raised in the amended answer, which was in response to the amended complaint.
These parties, Medeiros and DeLucre, did not file an answer to the amended complaint. They filed a motion to dismiss in response to the amended complaint.
In your brief, you go paragraph by paragraph through the paragraphs that the judge, in her words, denied. In other words, found would support a claim of activity that was outside of Atkinson immunity. And I wanted to talk in particular about paragraph 45, which you address on pages 21 and 22 of your brief. And you say that paragraph 45 alleges that Union President Medeiros' alleged actions were undertaken, at least in part, to support Union member Silva. So you say at least in part, but unless the complaint alleges that they were entirely undertaken in a capacity as agent of the union, don't we have to, taking the complaint and drawing all reasonable inferences in the plaintiff's favor, don't we have to construe that as alleging activity that is outside union agency? And the specific allegation in paragraph 45 is that Medeiros promulgated these knowingly false rumors in an effort to humiliate TAVARES, create a more hostile environment, and to support Silva in retaliation. Why isn't that by itself enough?
Because it's a single act. And so I would disagree with the proposition that if there were diverse motives for the single act, that you don't get the protection. As long as one of the motives was to act as the union's agent, I think that's enough to give you the immunity.
What case says that?
I don't have a case that says that, Your Honor, but that would be my argument.
Do you think there is one?
I honestly don't know.
Would it make sense in terms of the Atkinson rationale?
Yes, I think it does.
You have mixed motives.
I think it does because I think that the concern about suits being used as intimidation against union agents and the concern about holding union agents to a higher standard than the union would override any concern about, that there may have been some personal motive here too. I think the whole personal motive versus union motive distinction, dichotomy that the trial judge tried to draw here is a false dichotomy. I think that as long as the actions were motivated by the union purposes at all, I think they're covered by this immunity. That would be my argument.
But that Atkinson case, wasn't that was based on a federal statute, 29 U.S.C. Section 185. We don't have a cognate state statute.
That's absolutely true, Your Honor. And if the development of this doctrine had stopped after Atkinson, it probably wouldn't be applicable here. But this doctrine has developed far beyond that. We have the Montplaisir case, which applies it in a fair representation context. We have the Best v. Rome case, which applies it under Massachusetts. It's a federal case, but they're purporting to apply Massachusetts law. And now we have this court's own case in O'Keefe, which clearly adopts it as a matter of Massachusetts law. So you're right. Atkinson by itself doesn't get you there, but a lot has happened since Atkinson.
Could you also help me on something? As I read the complaint, there are 6 counts that pertain to the defendants. Which ones are still in play?
I think the only ones that are still in play are...
Because the judge didn't actually explicitly say which ones were dismissed, right?
There are 2 accounts that are sort of add-ons at the end, which are accounts by Plaintiff Sinna against Medeiros alone. One of those doesn't make any sense at all because it's a Section 4 sub 1 claim, and under that section you can only sue employers. So I'm going to say maybe that was even just a typo. The other one that's added on at the end has an allegation about some unspecified, that Senna learned about some unspecified list of particulars that was supplied through Medeiros from the Chief Court Officer Kurt, which I submit just is not a cause of action. The ones that are still in play are the main ones that were part of the original complaint as well, and that's counts 7 and 8 as to Medeiros, and counts, I think it's 10 and 11 as to DeLucre. Those are the counts that allege retaliation, coercion, and aiding and abetting.
So when the judge wrote allowed in part, denied in part, really, it was entirely denied. Is that what you're saying?
No, I don't think you can interpret that way at all, Your Honor. She went paragraph by paragraph and allowed the motion as to several paragraphs.
But she didn't dismiss any count.
She did not
So
dismiss
what
any count.
and it seems to me she didn't strike any of these allegations, because even on your theory, the union could be liable in respondeat superior for this conduct, because it was within the scope of their responsibility as union agents.
Yeah, as to the union, that's right, Your Honor. But I think she did in effect strike these counts, or these allegations, as to the individuals.
So she was ruling on whether these particular allegations could be the basis for individual liability.
Correct.
Okay. So in other words, did they allege or did they support an allegation of some unlawful conduct that was not taken as an agent of the union?
Right. I think that was her thought process. And there are many allegations in the amended complaint that clearly do refer to actions taken as
Yeah,
union
and
agents.
those are the ones that she said were allowed.
Ones she
All right.
denied.
But they all remain in the complaint. The question is whether if she had said everything was allowed and there was no allegation in the complaint that was sufficient to allege liability on the part of either individual defendant outside of the scope of agents of the union, then she would have allowed the motion to dismiss. I take it.
I think that's right, Your Honor. But this whole confusion sort of points to the ill-advised approach that the trial court took here. And again, what I call the false dichotomy between union action and individual action. And the other thing is that in every case where the trial judge denied the motions, the allegations, although the allegations don't specifically allege action as a union agent, they also don't specifically allege action in any other capacity either. Every one of these allegations is in the category of labels or formulas or conclusions.
Well, some of them might not have risen to the level of what Iannaccino requires. But when we think about construing the allegations and drawing all reasonable inferences in the plaintiff's favor, does that mean we draw them in favor of individual liability, or do we draw them in favor of them acting as agents so that the union would be liable, or can plaintiffs plead in the alternative so that we have to construe them in both lights?
I'm not really following that question, Your Honor. I think the plaintiff's speculations and labels. And as to the allegations that survive the motion to dismiss, they just don't do that. They just are, conclusory statements that, the defendants aided and abetted, the defendants coerced, the defendants retaliated. They don't tell you what did the defendants actually do. Yeah. In no case do they say, what did the defendants actually do?
Yeah, well, if we go back to paragraph 45, that contains an allegation that Medeiros promulgated knowingly false rumors in an effort to humiliate TAVARES and create a more hostile environment. So let's assume that that's enough for Iannaccino purposes. Let's assume we don't agree with you that any action taken even in part motivated by responsibility as an agent of the union is enough to establish liability. So if this is a specific allegation of some conduct that, if it wasn't undertaken for the union, would establish or could establish their individual liability. Do we construe that allegation in favor of the conduct being taken outside of their scope as agents of the union? Is that more favorable to the plaintiffs, or is it more favorable that they were acting within the scope of their agency so that the union would be liable? I'm not making myself clear, I apologize.
I understand what you're saying. I'm not sure that I'm the person to answer that question. I might be better addressed to counsel for the plaintiffs. How do they want that construed? But I would submit that again, it should be construed if it refers, and your paraphrase left out the part about wanting to help
Right.
Member Silva. If it could be construed that the actions were motivated in part to help Member Silva, then that should be covered by the immunity.
Well, if
the
you do
idea
find
that there's this different, again, I think the dichotomy between individual motive and union motive is just not the right way to analyze this, as long as there's any union motive.
All right. Well, if you do find a case that stands for that proposition, please be sure and let us know.
All right. Thank you, Young.
Thank you. And we'll hear from Mr. Chundy.
Thank you, Your Honor. I assume it's afternoon. Good afternoon. If I'm wrong, won't be even the second time today. My name is Christopher Trundy. May it please the court, I represent the two plaintiffs, two African-American court officers, one of whom was fired as a result of the request of these two individuals, as alleged in the complaint and set out in detail in the amended complaint. I just want to talk about this. There's a lot of discussion about the rule of Atkinson and how Atkinson has set this all up. And I do discuss the fact that every case that is cited, all the jurisprudence in this case, in the appellant's brief, turns on behavior and disputes between, in Atkinson, it was the employer going after union agents because of an illegal strike. And of course, as the court noted, that exclusion that was adopted there was based on a specific federal statute.
Right. But we now have the Duddy case, which has adopted at least some part of Atkinson as state law.
So let's talk about that. So that particular...
And that was a suit by a union member against someone who is determined to be an agent of the union.
Correct. And in that case, it's reference to Atkinson, and importation of Atkinson uses the language of Atkinson, which says you cannot sue union agents or members, whether in contract or tort, for violation of a collective bargaining contract for which damages the union itself is liable. This is not a case where these two individuals are suing in the capacity as union members.
But Duddy was if I'm not mistaken, was a malpractice claim.
Right. So, there were several of those in federal jurisprudence as well, where members say, I was appointed a union lawyer didn't do the job for me. We know as lawyers that union lawyers do not have the same obligation to members of the collective bargaining unit as a typical attorney-client relationship. I don't take any issue with any of that. What I think we're looking at here is the fact that this union and these two individuals, one of whom was both a union president and the immediate supervisor of both of these women under that bizarre situation which no longer exists in Massachusetts, these two individuals in their capacity used their union role to trigger a grievance against two individuals. Those individuals were not in their role as members. They were the target of the union. So although they were paying union dues, this is not a union breach of contract claim. This is you used your union role in order to engage in race discrimination and retaliation, and to aid and abet and give cover to other individuals within the hierarchy of the security service to go after these two women. That takes it completely outside the scope of any of this jurisprudence, including the O'Keefe case, because it is not within what I refer to as core union activity. It's not, the standing of my clients isn't contractual. They are outside the union at this point. The union is coming after them through these two individuals.
But didn't Judge Selya in the Montplaisir case, there was some interesting language in that case. He seemed to address that very issue. He said, however the claim is inventively cloaked, the conduct of the party just has to be within the ambit of the collective bargaining process.
Absolutely.
That's a pretty broad statement.
Well, but I think that language emanates from Sinclair, from the Sinclair case. He imported that from Sinclair, which says you can, however you style it, if you're one of those parties to the contract, whether you're the employer or whether you're a collective bargaining member, going after the union through its agents is impermissible. I think you got to, the key question is a claim of race discrimination that is where you're not even claiming it's in, a breach of the duty of fair representation, which has been raised here. This isn't fair representation. This is the union coming after you. Now, it just happens to be your own union, but they have essentially, for these purposes, they have moved you outside of the union. They are coming for discriminatory purpose. Now, we have, of course, 151B in Massachusetts, which creates individual liability, aiding and abetting, retaliation. That also creates liability for unions. There is no comparable federal statute. There's no individual liability under federal law. So this theory that we now want to take this O'Keefe decision and import it to say, if there's a union nexus, whatever kind of misconduct or tort you engage in, go sue my union, okay? That doesn't follow from any federal guidance. That is now something you are being asked to expand O'Keefe to a place it's never gone before. I would say this.
I did want to make sure you get to this, and I'm sorry I didn't ask you at the outset, but when you mentioned liability, it reminded me, is this immunity from liability or immunity from suit? Let's assume that it applies.
I think that they're claiming immunity from suit, but I really think it's immunity from liability, because the question is, there is a factual question whether or not the intent in your role is your intent to further a union objective that incorporates these people, or doesn't it?
But how does whether there's a factual issue bear on what type of immunity it is? I mean, there may very well be factual issues, but...
I think that my reading of the case law is that the immunity is limited to a legitimate role within the union collective bargaining.
But is it immunity from suit, or is it immunity, in which case they can appeal it now?
I think that the immunity is something that's sort of, the term immunity was never even used in Sinclair. So this whole thing.
But it's been used since. I mean, it was used in Montplaisir and many other cases.
It's unclear to me from reading the limited number of cases we have whether, I do think that there are cases that say that you are immune from suit if you're clearly, such as the lawyer, in Montplaisir and in other cases, where you're clearly just acting as a union person in a traditional union scope. That is not what we're dealing with here. And I do just want to say one thing before my time runs out, because there is this talk about the policy justification for this, to protect unions in America, which was, some people lost their homes, according to one of these cases early on, Sinclair or something. And what we're talking about right now is saying that any individual with a union nexus can engage in intentional race or other discrimination, and then they can walk away, and their union will have to pick up the tab, which, as we know, can be in the millions or high millions for cases like this. And this is clearly, from the plaintiff's point of view, a substantial punitive damages case when, for example, as the record shows in the amended complaint, when Tracy TAVARES was terminated by the trial court, they cited as a reason the request of her own union. And I would also suggest that there becomes a conflict of interest between the union and the members on this, because if you have actors who are doing things in the...
Well, doesn't that suggest it's a duty of fair representation claim? That
No.
kind of cuts in favor of the claimed immunity, whether it's liability or...
No, I don't think it's fair representation. It's not representation at all.
Well, I mean, the question is has the union breached its duty of fair representation?
I think that there's clearly a claim that could have been brought, but there was no claim that was brought.
I'm actually interested in that. I mean, does the union, and I should have asked your opposing counsel this, does the union have a position on whether liability applies here? And if this were a breach of duty of fair representation claim, why didn't the union say that it's in the primary jurisdiction of the CERB?
Well, I allude in the brief to at least one, I think the original answer of the union suggested we have no knowledge.
Well, but,
Yeah.
all right, you know,
I mean,
you
that's the
amended your
best I have.
complaint.
I can tell you this, there is a huge body of discovery that's taken place that's outside of our record that I'm not going to get into here because it's inappropriate. I do think that it is more appropriate for these issues to have been addressed on a full record to the court as a summary judgment matter, so that may weigh on whether or not it's immunity from suit as a practice, whether it should be or shouldn't be.
Well, even in Lynch v. Crawford, which was,
Right.
the court ultimately held was immunity from suit, the court said this can't be resolved, whether the defendant has immunity can't be resolved on summary judgment.
And I think that
So
goes to...
immunity from suit doesn't guarantee you an early dismissal.
Well, right, and I think it should be done that way because although we can say that somebody was acting in a union capacity and doing something that ostensibly they're entitled and empowered to do as a union person, that's no different than any other person in a discrimination suit where, for example, the boss has the right to terminate you or the boss has the right to demote you. The question is not whether the boss has the right to do that. The question is whether or not the motivation for that is discriminatory. So then the question, I think, in these instances should be whether or not these actions by the union and by individuals acting under the scope of the union is intentional or not.
So do we look at mixed motive cases under 151B?
Yes, we do. Yes.
And what would they tell us?
I haven't.
If you have a motive, if an employer proves a motive that was legitimate and the plaintiff proves a motive that violated 151B, then who wins?
Well, I think if there's evidence that it played a role, you win as a plaintiff under 151B. I think that is the law. I mean, there's often mixed motives. And often mixed motives between different kinds of discrimination, age
But
and race.
the problem, though, is going back to the Montplaisir case, there the court wrote that the Atkinson protection doesn't vanish even if illegal tactics are employed. So, in other words, if the agent for the union does something that's illegal, that agent still has the protection of the immunity, correct?
Well, I'm not sure, I'm not sure how far they were going in that case. I mean, it is a First Circuit case, but I don't think, again, I would say this to this panel, that the only decision we have on this that's within state jurisprudence is a fellow decision from the appeals court. This is a very significant conflict between anti-discrimination law in Massachusetts, which we don't have a parallel in federal law, and union policy interests. And in all of the federal jurisprudence, they're talking about squarely somebody acting within a union capacity involving rank and file, I believe in that case, going after somebody for not doing something they requested their union personnel to do. And I think that sets it aside, once again, from this case, which is not a claim by these two women that, oh, the union didn't do what we asked. What they're saying is the union came after us for wrongful discriminatory motive. And I don't think that those cases really help us to get to the point where you want to make a solid decision that weighs a clear statute that has named individuals and has named unions as potential parties. So with that, I know I'm virtually at the end of my time.
I did want to make sure you're not aware of anything in the record where the union itself took a position on whether
No,
these
and
individual defendants were immune.
And my expectation is that at trial, the union is going to disavow them. That's my expectation. Thank you.
All right, thank you. That concludes our sitting for today. I'd like to thank our court officers and